Okay, let's do a little illustration to show how this works. You have your asset protection trust represented by this purple box here. Inside you have your LLC. This LLC owns a bank account. Want to know how to protect your assets in the event of a divorce? Now I get it. No one enters a marriage thinking about the end, but in today's world, being prepared is essential. So let's be real. We insure our cars, our homes, even our phones. So why not insure our marriages from divorce? This is the business guy. I'm the CEO of Asset Protection Planners. We have attorneys on staff, and we're the nation's largest asset protection firm. And today, I'm going to walk through a rock-solid strategy, a strategy that doesn't involve awkward conversations about prenuptial agreements or legal battles. So buckle up because we're diving deep, and you'll come away not just knowing how to protect your assets, but really how to sleep better at night. And trust me, it's a relief knowing your hard-earned money is safe. Now, you know what they say, hope for the best, but plan for the worst. And no, that's not a secret to a lasting marriage, though I'm sure it wouldn't hurt. So let's dive into what I like to call the ultimate preemptive strike in asset protection, and please subscribe so we can see each other again. So why is this important? Let me share a few sobering statistics. According to the American Psychological Association, roughly 40 to 50% of marriages in the U.S. end in divorce. I mean, think about that. The odds are almost like flipping a coin. But here's where it gets scarier. In high net worth divorces, it's not uncommon to see individuals lose half of their assets. Yes, half. And in some cases, depending on state laws and how the assets were handled, that percentage could be even higher. For example, one of our staff attorneys got divorced before he joined our team and learned about asset protection.
Don't sit in that position. Take action.
Now, the judge gave his wife 100%, yes, 100% of all assets. The judge reasoned that as an attorney, he could earn it all back again. And he replied, well, the law says half. He appealed the case to the Florida Supreme Court, who overturned the judge's ruling. So he took the new ruling back to the original judge, and the judge refused to comply and insisted on giving his wife everything. It was only after 3 years of fighting in court that he got a favorable ruling. And by that time, she already had all the assets. So imagine this. You've spent years, maybe decades building your wealth. You've worked hard, invested smart, and now a judge who doesn't know your life story is determining how much of your wealth your ex-spouse gets. I mean, that doesn't feel right, does it? But here's the kicker. It's not just unfair. It can be financially devastating. The courts don't care if the assets you're bringing into the marriage are yours or theirs. All they care about is what's fair under the law. And that can often mean dividing everything right down the middle, or even more in the case of our staff attorney. And that's especially the case if assets have been commingled. And you have what many attorneys call results-oriented judges. They don't follow the law, they just follow their gut feeling about how they think the case should go. And sure, the law technically states that separate assets, those owned before your marriage, remain separate. But here's the catch. If you've commingled those assets, say by using marital funds to pay off the mortgage on a property that you owned before the marriage, you might be out of luck. Courts can determine that once those assets that were separate are commingled, that's now joint property. And that's where things get dicey and goes into the hands of the judge. Now, if you're thinking, well, that won't happen to me, I'll just hide my assets in a treasure chest in the backyard. Well, I hate to break it to you, but that doesn't work either. In fact, that's called fraud, and judges don't really like fraud, and you could end up living in a place you don't like for a long time. So instead, let's move into the legal and airtight way of protecting your assets. Now, a lot of people might say, well, I'll just sign a prenuptial agreement. And yes, prenups can be effective in certain cases, but here's the problem. Picture this. You're sitting down with the person you're about to marry, the love of your life, and you whip out a piece of paper that says, just in case things don't work out, I want you to agree that what's mine stays mine. Talk about a mood killer. Not exactly the best way to start wedded bliss, right? Not only does that conversation get awkward, but more often than not, prenups are challenged and overturned, especially if one party argues that they signed under pressure without full legal understanding. In other words, they're really not bulletproof and they get holes poked in them left and right. So how do we avoid this? The answer is a cook Islands Trust. This strategy is like having a financial shield, a barrier between your assets and anybody who might like to take them away, divorce or not. And here's the beauty of it. You don't have to have that uncomfortable prenup conversation. You can set up this trust long before marriage, and it's done quietly and securely. Why the Cook Islands, you ask? Well, let me tell you. The Cook Islands is one of the world's most trusted jurisdictions when it comes to asset protection. U.S. trusts don't work in this case because U.S. courts have jurisdiction over U.S. trustees. The Cook Islands legal system, on the other hand, is designed to make it incredibly difficult or even impossible for anybody, even with a determined ex-spouse with a high-profile lawyer, to get their hands on your assets. So here's how it works. The U.S. courts say, give me the money, or UK, Australia, New Zealand courts for that matter. Our Cook Islands Trust Company law firm says, no, not going to. You don't have jurisdiction down here. To put it simply, the Cook Islands is the Fort Knox of asset protection. But wait, there's more. Don't stop at just the trust. To really make sure your assets are locked down, we place them inside of a Cook Islands LLC. Why? Because this adds an extra layer of legal protection and control. The trust owns the Cook Islands LLC 100%. You're the initial manager of the LLC and the signatory and the bank accounts. And if you need our law firm to step in as LLC manager to protect you, they can. Think of it like building a moat around your fortress, and you have the button that opens and closes the drawbridge. So not only do they have to get through the trust, but they also have to navigate through the LLC, which is nearly impossible to penetrate. So let me paint a picture for you. Imagine you have real estate investments and savings that you want to protect. We set up the trust, you place your assets into it. With real estate, we use land trusts, and for rental properties, we add LLCs. We record equity stripping line of credit mortgages on the properties to make them very unattractive to take. You retain control over everything until you need our law firm to step in, while keeping all of the assets shielded from outside threats. Okay, now let's focus in on your liquid assets like cash and investments. For those, we recommend setting up an international brokerage and bank account. We often use a Swiss bank account under the protection of the Cook Islands Trust. You've heard of Swiss bank accounts, and there's a reason why they're known for secrecy and security. So combining the Swiss account with your trust and your LLC really adds a trifecta of protection. Your money is safe and your privacy is intact. And we open the account in the name of the LLC that's inside the trust. And again, your Cook Islands Trust owns 100% of the LLC. Now, speaking of Switzerland, it's ranked as one of the safest banking jurisdictions in the world. You get confidentiality and you get peace of mind knowing that your assets are out of reach from prying eyes. Okay, let's do a little illustration to show how this works. You have your Cook Islands Asset Protection Trust represented by this purple box here. Inside you have your offshore LLC in the Cook Islands here. This offshore LLC owns a bank account, investment account, and other assets. You are the manager of the LLC that holds the bank account, and you're the signatory on that bank account. Now, when the judge says, give me the money, at that point you can have our lawyer step in as LLC manager, and the judge can say, give me the money, and our offshore trustee law firm can say, hey, you don't have jurisdiction down here, and refuse to comply with that court order. Now, you can't refuse to comply with a court order, but our law firm, the Cook Islands, can. And I've been doing this for 33 years. I've been setting up asset protection structures. I have a Cook Islands Trust myself, and I know that if anything bad happens, I can have our law firm step in, and they can protect me from that court order. You can name yourself the beneficiary of the trust, and you can say that when you pass, whoever you want to inherit the assets in the trust can be the subsequent beneficiaries. So that's how the trust structure works. Let's take a look at the real estate and what we do there. Let's start with the home you live in, your personal residence. We put your personal residence into a land trust so you have flexibility that also gives you privacy of ownership from other outside lawsuits. We then take the LLC, typically that's the LLC inside of your offshore trust, and we record equity stripping line of credit mortgages against your home. Now that's payable to your own company, so you're not going to foreclose on yourself. You don't have to make any payments because it's a line of credit. And then when a legal attack comes, you can have that lien purchased by a third-party lender who puts the proceeds in a you can't touch it account within your offshore trust. And it's similar with rental property. In this case, a rental property is owned by the land trust. A beneficiary of the land trust is an LLC for extra legal protection. We don't use the LLC for personal residences because that can hurt your home ownership tax benefits. But for rental property, this gives an extra layer of protection by using the LLC. We have your LLC inside your trust, separate LLC, and that records an equity stripping line of credit mortgage against the property. And again, a third-party lender can purchase that mortgage down the road if that's really needed. It's when you need the bulletproof protection. So let's say you have 4 rental properties properties, and you have your personal residence. So here's your personal residence. Here are the rental properties represented by these 4 boxes here. And each property is in a separate land trust. And the beneficiary of the land trust for rental properties, not your personal residence, is an LLC. So you have 4 land trusts, 4 LLCs that are the beneficiaries of those land trusts. Then we have your LLC inside of your Cook Islands Trust, and that records equity stripping mortgages against all of the properties. That way it makes it very unattractive to take, gosh, we want to sue George, but George doesn't have anything. So whether it's a divorce or other type of lawsuit, this strategy can protect against many different kinds of lawsuits. So let me share a quick story. One of my clients, a successful entrepreneur, was preparing for marriage. He had substantial assets that he got out of his first marriage, real estate, a portfolio of investments, and a sizable cash reserve. Now, naturally, he wanted to ensure that in the event that things didn't go as planned, those assets would remain his. So we set up a Cook Islands Trust. He moved his rental property into separate land trusts owned by separate LLCs. We record equity stripping mortgages against the properties and then transfer the cash into a Swiss bank account. The entire process was seamless, and he didn't have to have that uncomfortable prenup conversation. So here's the interesting part. A few years later, the marriage didn't work out, but when his ex tried to go after his pre-marriage assets, she was met with a brick wall. The trust, the LLC, and the Swiss account kept everything protected. In fact, she had already obtained a ton from her prior marriage, so she was set financially. She was just after his next. So just as we had planned, not a penny was lost. Now, I know what some of you are thinking. This sounds like a James Bond movie. A Swiss bank account? Really? Yes, really. But here's the deal. While this may sound like something only the ultra wealthy do, the truth is anybody with significant assets can and should consider this strategy. After all, online banking makes it just like banking down the street. Now, a crucial part of this strategy is keeping those pre-marriage assets separate from anything that you acquire during the marriage. The minute you start using joint funds to, say, pay off the mortgage or maintain one of the properties, you risk commingling the assets. And that's a fast track to losing them in a divorce. But don't worry, there's a simple solution. Set up your trust, move your assets into LLCs, and make sure those assets are self-sufficient. That means your rental properties need to generate enough income to cover their expenses. And don't mix your personal or joint funds with them. So by keeping everything separate, you're drawing a clear line in the sand. And of course, once you're married, you're free to set up a joint living trust for assets that you acquire together, and that's perfectly fine. Just make sure that the new trust is separate from your Cook Islands Trust and keep those lines clear, and you'll be protected on both sides. And as an aside, you can also name your spouse or future spouse as a beneficiary of your Cook Islands Trust, stating that if you're still married within 24 hours of your passing, your spouse can then become a beneficiary of the trust, as well as your children, under the proportion that you wish. So the brilliance of this approach is its simplicity. You're not hiding anything, you're not breaking any laws, you're simply being proactive. So you've structured your assets in a way before the marriage, there's almost no chance that they'll be considered joint property in a divorce. We've also had people set up Cook Islands Trust during marriage when things get shaky. So let's face it, divorce can be messy, emotionally and financially. And with this setup, you're putting yourself in a position of strength. No more worrying about what's going to be taken away. So if you want to learn more about the Cook Islands Trust or how this strategy can work for you, click the link below in the description to visit assetprotectionplanners.com for a strategy session, and we'll walk you through the process, answer any questions you have, and help you protect your hard-earned assets before it's too late. And if you found this video helpful, don't forget to smash the like button, subscribe for more financial protection tips, and trust me, you'll be glad you did. And after all, isn't peace of mind the best asset protection? This is The Business Guy.